You're welcome to my channel. In this video, still in business law or company law, we are going to be talking about the formation or registration of the company. A company is formed by presenting certain documents to the company registrar for registration, and once these documents are all presented and the necessary fees have been paid to the company registrar, the company will be registered by the registrar and will be given a certificate of incorporation as evidence that your company has been registered. Let's look at the documents that must be submitted to the registrar in order for a company to be registered. The first thing that is supposed to be done is reservation of a name. This is the very first step to formation of a company. You have to first book the name of the company, and this is done by submitting a request for reservation of the name you wish to use for the company to the company registrar. But there are certain names which you will not be allowed to use by the virtue of law, and these include names which show concern with the government, names which are already registered or existing, names that confuse the public, you just twist some other company's name. They're not allowed because they will confuse the public, and names with illegal or abusive connotations. And once the name desired is available and it doesn't breach the above concerns, the name will be reserved as the new company's name, and no subsequent companies will be allowed to use. The second document is the Memorandum of Association. Memorandum of Association is also known as MOA. It's the most important document of the company, and it's commonly known as the company constitution. It's the document that determines what business the company is going to be involved in and what powers the company may or may not have. And in the case of Guinness versus Land Corporation of Ireland, in 1882, it was established that the Memorandum of Association contains fundamental conditions upon which the company alone is allowed to be incorporated. The Memorandum of Association contains the following information. First, it contains the name of the company. This is required by the Companies Act to be clearly shown in the Memorandum of Association because the name of the company is the identity of the company. Secondly, we have the Objects Clause. This sets out the principal activities that are to be pursued by the formed company. It shows the businesses that the formed company intends to do, and it's an optional section. You may choose to have it or not, the Objects Clause. The Memorandum of Association also contains information about limitation of liability or the Liability Clause. This states that the liability of members is either limited or unlimited, and this section is mandatory. The Capital Clause. The Capital Clause, it shows the capital of the company. Any company that is limited by shares must state its nominal capital and the value of each of the shares into which the share capital is to be divided. But if the company is limited by guarantee, the memorandum should state the amount that each member undertakes to contribute to the assets of the company in the event of winding up. Then lastly, we have the Associative Clause. The Memorandum of Association normally concludes with an associative clause by which the subscribers or members state that they are desirous of being formed into the company, like they confirm that they want to be part of the company. That's what we call the Associative Clause. Let's look at the alteration of the Memorandum of Association or alteration of the MOA. Alteration is like change. And it can happen in two ways, and the first way is alteration of the Objects Clause. We say the Objects Clause, it shows the activities that the company intends to do. And alteration of the Objects Clause, in order for a company to alter its Objects Clause, there must be a special resolution, and alterations can be carried out in order for a company maybe to carry on the company's business more economically or efficiently, when the company wants to enlarge or change the local area of its operations, when the company wants to attain any of its earlier objects by unimproved or new means which were not earlier foreseen, when a company wants to restrict or abandon any of the objects specified in the MOA, or when the company wants to amalgamate with another company or body, they can be able to alterate the objects clause or change the activities that the company intends to do or pursue. Another way of altering the Memorandum of Association is alteration in respect of the company share capital. The memorandum can be altered where the share capital of the company is being altered, and this is subject to companies limited by shares or companies limited by guarantee. And according to Section 63 of the Companies Act, such alteration of share capital must have been authorized by the Articles of Association or the AOA. When the company is creating some shares, or when the company is cancelling some shares, or when the company is converting paid-up shares into stocks, and lastly, when the company is issuing new shares. Another document that we have is the Articles of Association, or also known as AOA. The articles regulate the manner in which the company's affairs will be managed. They serve as regulations for internal management of the company, and they determine how the company's objects will be achieved and how the power is spelled out in the Memorandum of Association will be exercised. The Articles of Association deals with matters such as allotment and issue of shares, the rights attaching to shares, transmission of shares, conduct of general meetings, the appointment and powers of directors, and then the accounts and payments of dividends. Let's look at the alterations of the Articles of Association or change of the Articles of Association. A company can alter its Articles of Association by a special resolution. A special resolution is like an agreement passed by a majority of not less than 3/4 of such members as entitled to vote. And the alteration will generally be valid unless if it's illegal, unless when it conflicts with the provisions of the Companies Act, unless when it extends or modifies the Memorandum of Association. It can be invalid if it deprives members of the rights conferred to them by the Companies Act or by court, and when it requires a shareholder to take or subscribe for more shares or increase his liability to contribute to the company, and it can be invalid if it amounts to fraud on the minority. Let's look at the contractual effect of the Memorandum of Association, which is MOA, and the Articles of Association, which is AOA. According to Section 21 of the Companies Act, when the Memorandum and the Articles of Association are registered, they constitute the following 3 contracts. And the first contract is a contract that binds a company and all its members to the same extent as if each member had respectively signed and sealed the Memorandum and Articles, and they contain covenants on part of each member to observe all the provisions of the Memorandum and Articles of Association. Another contract is a contract that binds the company to each member. Any member may enforce his rights against the company by legal action, by the virtue of existence of the Memorandum and Articles of Association, even where the member did not personally sign the Memorandum and the Articles. They can be able to enforce their rights against the company. So it creates a contract that binds the company to each member. And lastly is a contract that binds the members to each other. Articles constitute a contract between the members among themselves. Each member has a personal right. And those are the 3 contractual effects of the Memorandum of Association and the Articles of Association. Yeah, they create 3 contracts, and the first one is a contract that binds a company and all its members, then a contract that binds the company to each member, and then a contract that binds the members to each other. Let's look at other documents that are required to complete the formation of the company apart from the Memorandum of Association and the Articles of Association. We have things like a statement of the address of the registered office. It shows the address of the office, where the office is to be located. Then a statement setting out the names of the subscribers and the secretary of the company. Also a statutory declaration by an advocate engaged in forming the company. Then lastly, a statement of nominal capital showing the capital of the company. Other things that are required when registering the company, we have stamp duty must be paid, and the higher the figure of nominal capital registered, the higher the charge for stamp duty. It must be paid to the company registrar. There is also registration fees. Registration fees must be paid to the registrar of companies on presenting the documents for registration. And after paying the registration fees, the last document is the Certificate of Incorporation. It serves as conclusive evidence that all the requirements of the Companies Act in respect to registration have been complied with. And that was all about formation or registration of the company. The first part is reservation of a name, and the last part is getting a certificate of incorporation. Thanks for watching. Don't forget to subscribe, like, comment, share with your friends, and watch my next video. We shall be talking about the effects of incorporation.